Can criminal proceedings under the POCSO Act be quashed under Section 482 Cr.P.C. based on a settlement between the accused and the victim, especially when the settlement results in their marriage? Do the circumstances of these cases justify quashing the proceedings despite the serious nature of POCSO Act offences? Petitioners argued that the settlements were genuine, supported by marriage certificates and victim affidavits. The continuation of proceedings would disrupt their harmonious family lives, including the welfare of children born from the marriages. The victim's consent and lack of grievances indicated a low likelihood of conviction, rendering further proceedings futile. State represented by public prosecutors likely argued that POCSO Act offences are serious, non-compoundable, and impact society, making quashment based on settlement inappropriate, as per precedents like Gyan Singh v. State of Punjab and Ramji Lal Bairwa v. State of Rajasthan. Amicus Curiae A. Parvathy Menon provided a report analyzing legal and societal perspectives, aiding the court in evaluating the quashment's implications. In Gyan Singh v. State of Punjab, the High Court's inherent power under Section 482 Cr.P.C. is not limited by Section 320 Cr.P.C. proceedings for non-compoundable offences can be quashed if it serves justice, but heinous offences like rape with societal impact should not be quashed based on settlement alone. Ramji Lal Bairwa v. State of Rajasthan, the Supreme Court cautioned against quashing POCSO Act cases based on settlements, emphasizing their societal impact and non-private nature. However, the facts involved a teacher's assault on a student, distinct from consensual relationships culminating in marriage. Vishnu v. State of Kerala. The Kerala High Court held that while sexual offence proceedings should not generally be quashed based on settlement, extraordinary circumstances may warrant quashment under Section 482 Cr.P.C. to achieve justice. Courts in Delhi, Punjab and Haryana, Madras, Bombay, Himachal Pradesh, and Odisha have quashed POCSO Act proceedings when the accused married the victim, citing family harmony, low conviction prospects, and justice. However, some courts, example, Himachal Pradesh and Gujarat, have refused quashment despite settlements. The court acknowledged the general principle that serious offences under the POCSO Act, being non-compoundable and societally significant, should not be quashed solely based on settlements. However, it distinguished the present cases due to their unique circumstances. Both petitioners married the victims after they attained majority, establishing stable family lives, as evidenced by affidavits, marriage certificates, and victim statements. The victims expressed no grievances, and one was pursuing higher education, with the petitioner caring for their child, indicating genuine rehabilitation and settlement. Continuing the proceedings would disrupt the victims and their children's lives, cause trauma, and serve no purpose given the victims' unlikely testimony against their husbands, making conviction remote. The court emphasized that quashment in such cases promotes justice by preserving family harmony and preventing abuse of process, aligning with Section 482 Cr.P.C.'s purpose. While serious POCSO Act offences typically resist quashment, less grievous offences or cases with mitigating factors, example, marriage and victim consent, may be quashed on a case-by-case basis, as supported by multiple High Court precedents. The court found that the settlements were genuine, the marriages mitigated the offence's societal impact, and continuing the proceedings would be unjust and futile. This judgment reinforces that while POCSO Act offences are serious, High Courts may exercise Section 482 Cr.P.C. powers to quash proceedings in exceptional cases where settlements lead to marriage and family stability. It highlights the need for a fact-specific approach, balancing societal interests with individual justice, and aligns with precedents favoring quashment in similar circumstances.